On this morning's Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thanks. Good to be with you.
Good, as always, with you as well. Let's get right to it. And one of the things the top thing we're going to talk about today is talking about probate fees. And of course, this really is in the line of transferring property to a revocable trust during life is to avoid probate at death. And I'm sure many producers out there who are listening have been involved in some form or fashion, probate cost. There's a lot to discuss, but a lot of things to go through, too, when you're determining that.
Mm-hmm. Yeah, that's true. And Greg, I've heard for many years, in fact, my entire career, from farmers and ranchers that they're concerned about what probate fees will be and how much it will reduce the value of their property that they can leave to their heirs. And there are misconceptions out there about what probate fees are. So hopefully we can kind of sort through the issues this morning and the pros and cons. But it has led a lot to push toward the creation of trusts. And that's neither good nor bad. It's just it's an option that one has. And I think if we lay out what the benefits and what the detriments are of each approach, then people can make an informed choice. But you don't want any more than is necessary in terms of cost to be incurred at death. And there's a cost associated with a trust, just like there is a cost associated with probating a will. But I remember early on in my career, we were in Nebraska. I was practicing with a firm in North Platte, and my wife and I and our daughter, this was before our son was born, we lived about 35 miles north of town up in the Sandhills, and I ended up becoming the county attorney in Logan County, Nebraska for a while. And there were these people that would occasionally come up to me either on the street or at a school function or just walking around town, and sometimes they'd stop by the house, and they were upset because in that rural community, and it's the only incorporated town in the county, but there's a weekly newspaper, and the couple of older ladies that ran the newspaper had a penchant anytime anyone died of publishing the contents of the decedent's will, and it upset people. And so they were coming to me wondering, they were coming to me in my role, it was funny, as county attorney, and say, well, can't you prosecute these people? I said, well, no, it's not a criminal offense. You can do that. And they learned that when the person dies, that your will becomes a public record once it's probated. And it becomes part of court records, and you can go look at those things. And people didn't like that. So they said, well, what can we do? And, well, you could have a trust. And that generated some trust business for the firm, which was an interesting way to generate business for the firm as a new attorney. But that is one thing about a trust. A trust is private, and the only thing that becomes published after you die is a certificate of trust existence that tells the world that you had a trust. It doesn't tell the world what property you had or who gets it. And so privacy is a big issue for farmers and ranchers, and a trust will help with that compared to a will. Now, in terms of saving taxes, no, they don't save any taxes at all. A properly drafted will and a properly drafted trust will end you up in the same point from a tax standpoint. And there's a lot of misconceptions about that. But privacy is a real issue for people. And you can accomplish that with a trust. And Greg, I would say another thing, particularly with our farm clients, is there's a lot of untitled property that a farmer or a rancher has. You think of livestock, you think of tractors and combines, machinery and equipment and the like. And that can create administrative issues when a person dies if you don't have a trust. But if you transfer all of that by a bill of sale over to a trust, it could be a revocable trust or it could be a trust set up under the terms of a decedent's will, then that solves a lot of those administrative problems. The trust owns it. The decedent in it didn't own it at death. So it can solve some issues. And then, of course, the fee issue is a big issue for people. Well, what's the comparative cost of a will compared with a trust? It does cost to probate an estate. It does cost to administer a trust. And it's that fee issue that came up in Kansas recently in terms of probating a will.
Yeah, a general overall thought on that is it literally state to state as to what that fee may be depending on the specific laws of the individual states?
Well, it is. State laws differ, and in some states, a flat percentage of the gross estate value can be charged as an attorney fee for the estate, and that can range anywhere from about 1.5% to 6% or even higher. You get into states such as the Northeast or out in California, for instance, and it's going to be a higher percentage, a pretty high percentage compared to other parts of the country. Now, in other states, you have statutes, excuse me, that say that you cannot charge a flat percentage fee unless you can justify it by your records, and that's Kansas. We have the Kansas Rules of Professional Conduct, where the courts use 8 factors for determining what is a reasonable probate fee, and attorneys are subject to that. You don't want to violate, as an attorney, the Kansas Rules of Professional Conduct. So you can't charge a flat fee without any billing records to support the fee being reasonable as determined by the court. So in Kansas, we always have the courts that sit there as a check on what the fee is that's being charged by the attorney handling a probate estate.
And that, or as you mentioned in some of the notes you gave me, there are specific factors, it looks like 8 factors that really go into this.
Yeah, and I'll run through them real quick. One, how much time and labor was required in handling the estate? What's the novelty and the difficulty of the questions involved and the skill that's required to perform the legal services properly? So that first factor recognizes that not every estate is the same. You have simple estates. You can have estates that are really complex because there are detailed tax and property issues. There may be oil and gas properties involved, and so you got to do a lot of deed work. An examination of deeds and titles, and so that can vary. The second factor is how likely, what is the likelihood, let me phrase it this way, if it's apparent to the client that the attorney's acceptance of doing this job, handling the estate, will preclude other employment by the attorney. In other words, how much else do they have to give up? And that's tied kind of to that first factor. How complex is it? Third is what's the fee customarily charged in the locality for similar legal services, and then fourth, the amount involved and the results obtained. Next one is the time limits imposed by the client or the circumstances, and then the nature and length of the professional relationship that the attorney had with the client, and then the experience, reputation, and ability of the lawyer performing the services, and then whether the fee is fixed or contingent. Those are all the factors that the probate court will consider in determining whether the fee requested by the attorney for handling the estate is reasonable.
As an example of this, you've got a recent or fairly recent case, well, actually a very recent case, that came out of Southeast Kansas.
That's right. This came out of Chautauqua County, and this is an opinion of the Chautauqua County District Court. And what you had was an attorney that had served as the representative of the conservator of an individual for 7 years. That individual eventually died. The conservator becomes the executor of the estate. The attorney is handling the estate. And during the conservatorship years, the attorney provided an itemized billing statement for the conservator showing the number of hours spent and on particular items. It was very detailed, and there were no problems with that. The conservator paid the bill. Well, when the estate happened, the executor let the attorney know that he expected to be billed on an hourly basis with itemized billing statements, and the attorney said, no, I'm going to bill it on a 3% flat rate of the gross estate value of the estate. And here we had about a $4.6 million estate, had farmland in it, had oil and gas properties in it. But as the court said, pretty basic, pretty easy to do. The attorney was well experienced in oil and gas, had over 40 years of experience doing that. This for this attorney fairly simple. And he told the executor, no, I feel comfortable taking a 3% fee. Well, I bet he did. And the executor said, no, I want the previous relationship we had in terms of billing to continue. I want your hourly rate, Quote me an hourly rate, give me itemized statements. Well, the attorney didn't do that. It comes down to May of this year, and he generates a billing statement, never having generated a billing statement at all for working on the estate. And it said, I want my 3% fee and $137,000 to handle the estate. Well, the local magistrate judge allows it, and the executor appealed. And that's where we get to the Chautauqua County District Court. And the Chautauqua County District Court applied the 8 factors of the rules of professional conduct that we just discussed and said, look, you're way out of bounds here. And the law has changed in Kansas. You can't just charge a flat percentage fee anymore. That changed back in 2009, where the court said at that point in time, no, that's not permissible. You have to support your fee with meticulous contemporaneous time records that show the specific task being billed. Otherwise, we're not going to allow it. Long story short, the court went through this and said the attorney was way out of bounds. And they cut the fee down to $58,000 from the requested $137,000. So that was deemed to be a reasonable fee. They said we couldn't put together any hours. We're just going to have to estimate some of the hours as to what we think is reasonable to handle this estate. And that's the executor was successful in getting $80,000 whacked off that bill.
The irony of that, what would the court say, that particular attorney also serves on the Kansas Board of Discipline for Attorneys?
Yes, that's particularly bad about this case.
Which really, in the end, it goes back to the professional conduct, as you mentioned, about those 8 specific items to be able to do, really not justified.
That's right. And the lesson for people listening today is if you're wondering about fees, the Kansas courts do sit there, I think, as a pretty effective break, so to speak, on probate fees that attorneys would charge. And the fees have to be justified. You have to have billing records. You have to itemize those and make sure that the executor knows what you're doing and how much time you spent on things. And that has to be presented to the court for approval. It's a little bit disconcerting to me that the magistrate judge allowed this. Perhaps that judge didn't know about the Kansas court opinions, that it kind of changed the scope of this and the groundwork back in 2009. But I think the district court's right here. When you apply the 8 factors, some of them weren't relevant in this instance, but some of them were, and the attorney did not come, those did not fall in the favor of the attorney in this instance. So all it took was a well-informed executor in this case to get the right result. And I think that's a good result. I think it's the correct result, and it's a good one for people to understand. The probate fees in Kansas are not that bad. And the courts do sit there as a pretty good arbiter of what would be just and reasonable and fair in a given situation. And that means the fees are going to differ where you're at in Kansas and on the expertise of the attorney. That doesn't mollify the fact that some attorneys are more experienced and better than others and can charge a higher rate, as long as you have itemized billing statements and you've got a record that supports that. So that's a big issue. And I think, Greg, this is probably not an uncommon situation, the facts of this case, in many rural communities across Kansas. That's just kind of been the practice for many years. We'll charge a flat fee and off we go. Well, times have changed, and attorneys are going to have to recognize that we can't do things that way anymore. And I think that's to the benefit of everybody. It's to the benefit of the legal practice and to farm and ranch families. But let that sink in and then make an informed choice as to whether you want to have a probate procedure at death or whether you want to have a trust and have a trust administration procedure, which probably is a little bit less costly on the back end, maybe more costly on the front end. But be well informed going in, and that's the whole point.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is our guest on the program this morning. Roger, other topics of discussion. This includes, if you have a business premises, the value of meals and lodging that are furnished on the business premises for the employer's convenience. Talk a little bit about that as far as tax-wise is concerned.
Yeah, this is a nice fringe benefit that our C corporation farming and ranching operations can provide for their employees. And actually, one of the seminal cases on this goes back decades, and it's a Western Kansas ranch. And what you can do is you can get a deduction at the corporate level. So the corporation gets a deduction for the cost of providing meals and lodging to the employees. And that value doesn't have to be reported as income by the employees of the farm or the ranch. It's a real nice provision in the code that allows that for C corporations. And again, it's just for C corporations. You can't do it with an S corporation or a partnership. And obviously, sole proprietorship, you're not going to be able to get this done. But that is under Section 119 of the code, which is the operative section for exclusion, the meals and lodging have to be provided on the business premises and for the convenience of the employer. Those are the two major provisions. Then another one is they have to be provided in kind. And if you do that, it's not wages for FICA and FUTA tax purposes. But the key to this is that you have to have a good business reason to have the employees on the premises at all times. And livestock operations tend to have an easier time at this than just grain-only operations, although it's not impossible for a grain operation to come up with a business reason why they need somebody on the premises at all times. You just think of theft issues, for example. But you might have grain drying operations. But livestock, it's a little bit easier. You need somebody there to watch the livestock, to break ice in the wintertime, to deal with livestock health issues. But if it's done right, it can be a nice tax-free fringe benefit for the employees and a deduction for the corporation.
And for those out there, as a business expense, to be deductible, it generally must be ordinary and necessary versus if the activity is deemed to be a hobby.
Yeah, that's true. We have to be conducting the farming operations as a business with a profit intent. We're not going to even get there to the meals and lodging issue unless we do have a profit intent or conducting it as so. Because if we don't have that profit intent, then IRS can argue that we're operating it as a hobby. And so then if it's a hobby, all sorts of bad things happen to you. You can't deduct your losses, and all the income from the activity, whatever income there is fully reportable. And those are the current rules, at least through 2025. And so there are lots of hobby loss cases involving agriculture that have been decided by the courts over the years, and there are many every year that are decided. So make sure that it's not a hobby. There was a recent Oklahoma ranch involving that particular issue. And we get into hobby issues, particularly with horse operations. The IRS seems to have trouble understanding that if you have horses, you're going to lose money for the first few years. And you can win and prevail that you have a business intent, but you better have a good business plan thought out to avoid the hobby loss issue.
And if you have an S corporation, that some out there who are living would, just a reminder that the S corporation is a separate entity from the individual themselves.
That's right. And this is an Illinois case involving a branch of Illinois' largest farming operation, the farm family. They have many entities and many family members that are involved. And they're downstate, kind of in the Decatur area. It's where this operation primarily is operating. But you can't, if you have expenses that are corporate expenses, and here it was property taxes and utility expenses, that needs to be written off at the corporate level, and then you file an 1120-S, and it flows through to the individual shareholders. The resulting income flows through. The shareholders in this instance decided, well, we're just going to deduct that on our personal return. And the court said, no, you can't do that, and it gets you into a whole bunch of other problems, too, and it gets you into penalties. And so you treat the entity as separate from yourself from a tax purpose, and that's the lesson out of that one.
All right, Roger, we are out of time, but as always, if people want to learn more about what we talked about earlier with probate costs or any of the other issues, that's going to be up on your blog?
It's already posted this morning, about an hour before we went live. I posted that one, and you can find that off of washburnlaw.edu/Walter, WALTR, and I'll also send it over to Rich Llewellyn over at K-State, and he'll get it posted on the Ag Manager site today, and then it'll also go to RFD TV.
All right, sounds good. Roger, as always, very much appreciate it, and we'll talk to you soon.
All right, thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he has been our guest this morning on the Ag Issues program here on 580 WIBW.